Tonight is the deadline that House Intelligence Committee Chairman Adam Schiff set on his subpoena for Attorney General William Barr to turn over the full unredacted Mueller report to the committee and the foreign intelligence and counterintelligence information collected during Robert Mueller's investigation. This morning, Chairman Schiff said it was too early to say, as of this morning, whether there had been progress in his talks with the Department of Justice about that.
Any progress in your talks with DOJ?
Too early for me to say for sure, but I should know more hopefully later today.
Are you prepared to hold them in contempt prior to that?
We're prepared to do whatever's necessary to make sure they comply.
And tonight, it is unclear whether the Justice Department has yet responded to Chairman Schiff's subpoena. We don't know any more about that. Today, the White House counsel sent a 12-page letter to House Judiciary Committee Chairman Jerry Nadler, rejecting all of Chairman Nadler's requests for documents in the committee's investigation of possible obstruction of justice by the President of the United States. The White House letter to Chairman Nadler said that the committee's investigation is, quote, not to further a legitimate legislative purpose and is, quote, outside the constitutional authority of the legislative branch. Chairman Nadler told reporters his reaction.
I don't know whether they're trying to taunt us toward an impeachment or anything else. All I know is that they have made a preposterous claim. Taking that position that a president cannot be indicted, they're saying only Congress can hold a president accountable. And now they're saying that Congress can't, which means nobody can, which means the president is above the law. And that is an un-American, frankly un-American claim.
Chairman Nadler and other House Democratic leaders are considering whether they should hold administration officials in contempt of Congress to highlight the Trump administration's unprecedented obstruction of legitimate congressional investigations. Today, in what might be the first time since 1934, the concept of inherent contempt was being discussed on Capitol Hill. 1934 was the last time we saw inherent contempt used by Congress. In 1934, the United States Senate issued subpoenas to a Washington attorney, and that Washington attorney refused to comply with those subpoenas, whereupon the Senate Sergeant at Arms went out and arrested that private attorney and kept him in custody for inherent contempt of the United States Senate. The Supreme Court upheld the Senate's constitutional power to take such action in that case. And now, 85 years after that, the chairman of the House Judiciary Committee was asked today about inherent contempt.
Some of your colleagues want to go for inherent contempt, try to find people who are defying subpoenas. Is that something that you're seriously considering at this point?
Yes.
What are you thinking about in terms of dollar amount of the fines?
I don't know. Very large amounts.
But would it be for the Attorney General?
It would be for it would be for anybody who was held in inherent contempt.
Yesterday, in federal court, a private attorney representing Donald Trump in a lawsuit trying to block a congressional subpoena of Trump financial records from an accounting firm used that very same line of argument that the White House counsel used today in that letter to Jerry Nadler rejecting the document request. William Consovoy, the private attorney representing the president, said in court yesterday that the congressional subpoena seeking Trump financial records did not have a legislative purpose, a legitimate legislative purpose. The judge was very surprised at that argument, since historically congressional subpoenas have been issued for investigative purposes as well as legislative purposes, very broadly defined. The judge said to the president's lawyer, so in your view, Congress's investigations in Whitewater, for example, and Watergate were beyond the scope of its constitutional authority? To which the president's lawyer actually said, I'd have to look at what the basis they were providing. The judge was stunned, as surely everyone in the courtroom was, that the president's lawyer was not sure whether the congressional investigations of President Bill Clinton and President Richard Nixon, both of which eventually led to impeachment proceedings, were constitutional. And the judge went back and forth with the lawyer at some length, finally getting the lawyer to admit that the Trump position is the president simply cannot be investigated by Congress. Here's the transcript. The court. So Congress, in your view, cannot determine, say, for example, a president had a financial interest in a particular piece of legislation that was being considered or an executive action that he was considering. In your view, Congress could not investigate whether such a conflict of interest, whether the president has such a conflict of interest, or the conflict of interest might in some way bear on decision making by the president. Mr. Consovoy, it would lack legitimate legislative purpose, and that is the test. Legitimate legislative purpose. That is what they're saying is the reason they are defying all of this, that the Congress has no legitimate legislative purpose. The Attorney General of the United States is treating the contempt of Congress resolution passed against him by the House Judiciary Committee as a joking matter. At a ceremonial event today at the Capitol, the Attorney General approached House Speaker Nancy Pelosi, shook her hand, and said loudly enough for people to hear it, "Madam Speaker, did you bring your handcuffs?" According to the Washington Post, Pelosi smiled and responded that the House Sergeant at Arms was present should it be necessary to arrest anyone, the person said, adding that Barr chuckled and walked away. Leading off our discussion tonight, our Democratic Congresswoman Madeleine Dean of Pennsylvania. She is a member of the House Judiciary Committee whose subpoenas are being defied by the White House. Lisa Graves is with us. She's a former Senate Judiciary Committee staff member and a former Deputy Assistant Attorney General under President Clinton. And Chris Lu, former White House Cabinet Secretary under President Obama, and he has also served as the Deputy Chief Counsel of the House Oversight Committee. Congresswoman Dean, what is your reaction today to that 12-page letter basically saying that there were just no purposes, no legitimate purposes stated by the Judiciary Committee for obtaining any of this documentation?
I think it's a stunning letter by the White House counsel. And I think Jerry Nadler, Chairman Nadler's response was exactly right. Imagine the letter came to us, to the chairman, suggesting that we had no business continuing with any more oversight as to the Mueller investigation, as to obstruction of justice, in light of what the Mueller report says. What I am constantly stunned by is members of the Republican Party or this president or the people who work around this president constantly referring to no collusion, no obstruction. Of course, if you read the Mueller report, you would find something very, very different. You'd find more than 160 contacts between the Trump campaign and Russia for the benefit of the Trump campaign, and they knew it. That Russia sweepingly and systematically interfered with our elections, and yet we have an administration that seems to care little about that as we go into the future and into 2020. And then we have Volume 2, which says that this administration, this president, showed evidence of obstruction of justice multiple times, as many as at least a dozen times. And Mueller himself said he's giving it to Congress, that it is up to Congress to go forward. He wanted to preserve evidence, even in the face of the fact that the administration destroyed evidence. And there were things that the Mueller investigation couldn't even get to. But it's just a stunning assertion by this counsel. But you saw and you just revealed the stunning, ridiculous arguments that were made yesterday before a court. So the truth bears very little on this administration and their legal arguments.
Chris Lu, we feel lucky to get you tonight and wanted you here tonight because you have experience at both ends of these kinds of subpoenas, having worked in the Obama administration, receiving these kinds of subpoenas from Congress, having worked in the Oversight Committee in the House, sending out subpoenas like this. What is your reaction to these developments where the White House is saying under no circumstances will they respond to anything?
Yeah, you know, I think the White House counsel would be smart to brush up not only on his law, but also his history as well. This idea, look, certainly Congress's investigative powers are not unlimited, but the limits are not to be dictated by the executive branch. And this idea that there has to be a legitimate legislative purpose, that's something that this White House has concocted. That being said, any first-year law student could come up with a dozen legitimate legislative purposes for every one of these investigations. So it's not only that they're wrong on the law, they're also wrong on the history. If you go back and look at the investigations they conducted of President Bill Clinton, I was on the House Oversight Committee during that period of time when Congressman Dan Burton, a Republican, did investigations of things like Travelgate, Filegate. We ended up doing Whitewater before it went to the special counsel. There was an investigations of President Clinton's last-minute pardons of Mark Rich, which this White House counsel has said cannot be investigated by Congress. So the history of Republican investigations is completely at odds with the arguments that they're making here. And it's important to understand, if you take their arguments to their logical extreme, this is a president above the law. And so, yes, it is odd that we're talking about inherent contempt, something that hasn't been used since the 1930s, but that tells you that we're in a little bit of uncharted territory right now.
Lisa Graves, I learned about inherent contempt today. You could work for several years in the United States Senate, as I did, and never even hear the phrase come up. That's the kind of rare territory we've stepped into.
Well, that's right. And I think that it's important to understand that those powers go back, almost 2 centuries, basically. There's a lot of black letter law about Congress's power. It's just that in this sort of statutory era, Congress has not used those powers. It's been able to get cooperation from presidents and from administrations, and it's also been able to use referrals to the Justice Department. Here you have a situation where the president and his lawyers, and interestingly and disturbingly, the White House counsel and his private counsel are singing the same tune with this argument that the Congress does not have these powers, the powers to investigate the president or to seek these documents. That's in defiance of black letter law. These are settled rules that have been settled for many, many years. And as you point out, inherent power has been rarely used because it's been rarely necessary to be used. But the fact is that the United States Supreme Court has commented repeatedly on the breadth of congressional investigatory power, on the power of Congress to seek material and get material, including talking about it being penetrating and far-reaching, a far-reaching power. And so these arguments are really in defiance of the law. In many ways, I think this is like the David Frost-Nixon interview without it being Nixon and David Frost, in which, Nixon said infamously, if the president does it, it must be legal. That's where we are. And so even though there's no fire, physical fire, it's as if the Constitution is on fire and the Article 1 of the Constitution is being blotted out by these guys.
Congresswoman Dean, we just heard your chairman of your committee, Jerry Nadler, say that it feels like the president is is taunting you into impeachment. Is the president taunting you into impeachment, and what next?
I wouldn't call it taunting. I would say that he may leave us no other alternative. He's certainly shown evidence of impeachable offenses. I'm a lawyer by training, and I'm a member of this Judiciary Committee, so I care very much about process and making sure we get the truth before the American public before we do something as grave and as important and possibly very necessary under this administration. So the president may just be leaving us no other alternative. But something I wanted to make sure I make mention of is the fact that as important as all of this is, and as extraordinary as it is that we might be talking about inherent contempt, and I too had to brush up on what that meant as a member of Congress, it's extraordinary that we are pushed to that point. And also, what I hope that your listeners, your viewers, want to know is that while we're doing this, this is a Congress that is both walking, chewing gum, and flossing at the same time, is what I like to say. We have to do it all. It is important. It is constitutionally our duty to do oversight on an administration that is the most corrupt, divisive, deceitful, cruel administration that I've ever seen in my lifetime. But we also, you have noticed, you have seen us. We're passing legislation. This new majority is passing legislation, whether it's regarding gun violence, which the Senate is sitting on their hands, whether it's regarding health care, prescription drug pricing, H.R. 1, which is good governance and anti-corruption. We are doing it all. And then we're also working back in our districts and working on issues like in my district, we have an issue of clean water. So this is a Congress prepared to do it all, walk, chew gum, and floss at the same time, but we will not be shirking our duty of oversight on this corrupt administration.
Chris Lu, if you were still in your old job on the House Oversight Committee, what would you be advising the House to do?
Well, I think exactly what they're doing. I mean, the House needs to consider every power it has at this point. It is trying to get, both on oversight and judiciary, trying to get these documents from other sources. I'm confident that some of these will prevail. I mean, obviously, the court case that was being argued the other day involved the House oversight and financial records. We also have, for instance, in the House Ways and Means effort to get the president's tax returns, there may be a way to backdoor a way to get that through New York. So I think that there are private entities that Congress will be able to get this information through. But it is important to understand, again, history in all of this. If you go back to Watergate, Article 3 of the Nixon impeachment was for President Nixon willfully disobeying subpoenas of the House Judiciary Committee. So I don't know if this is a president who is consciously trying to bait the House into impeachment, but there's certainly grounds for it if we get to that point.
Lisa Graves, take a quick last word with your advice as a former Senate staffer to the House. And I understand that the House doesn't like to get advice from the Senate, but go ahead.
I appreciate that. You know, I think that I have tremendous trust in Congressman Nadler and the other chairmen to really pursue this. I know that they've got a great team on board, and they're looking at all options. And I think they have to act. They have to act both morally and for the sake of our Constitution. They have to defend the rule of law in the face of this incredible defiance. It's their duty, and I know they're up to the task.
Congresswoman Madeleine Dean, thank you very much for joining us once again tonight. We really appreciate that. And Lisa Graves, Chris Lu, thank you both for joining us. Really appreciate it. Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.